today. It is that evidence which is the best available evidence. Any audit of the election result, my lords, my ladies, must start with the voters' roll actually used at the election. It is part of the sealed election residue. It could have been obtained. Evidence of the actual number of ballot papers delivered to each polling station, which would have been verified by all parties before the commencement of polling. That too constitutes part of the sealed election residue. The actual number of ballot papers utilized at each polling station, and the primary entries of the tally, which are the forms V11. These are available. And in Nyati versus Ngube, that is the Gwanda election petition 2005 2ZLR 204, it was held that there are limited grounds upon which a petitioner would be refused access to examine electoral material. In the present matter, my lords, my ladies, it is common cause that the applicant does not wish to relate to the contents of the sealed electoral residue. He does not wish to do so for fear of the obvious. And it is that the contents of those ballot boxes will disprove his thesis. Now, where does he get the figures? Where does the applicant get the figures? Numbers don't lie if they are correct. Numbers don't lie if they are extracted from the original keeper of those numbers, who is deemed by law to have acted lawfully unless established beyond a reasonable doubt that that keeper of the official record was involved in some criminal enterprise. The applicant relies on Annexure C to the founding affidavit as bringing about the various so-called discrepancies. My lords, my ladies, he simply relates to a schedule. He does not tell us the origin of this lady may bear with me. $92.90. I'm advised that it's at page 132. That's volume 1, my lord.
Volume 1, page 132.
Page 132. There is a document there that is headed in dashboard 2. Who originated this document? What materials did he use? Where did he get those materials? This document of mysterious origins cannot be used to pluck figures out of nowhere and allege that certain statistical information is correct. But we do have a clue as to the source of some of the information there. And that appears from the affidavit of Dr. Ouko Otumba. That's at page 43 of volume 1, my lords, my ladies. Page 43. Under sources, he says that he used the second and final voters' roll prepared and submitted to the stakeholders by ZEC. There is problem number 1. in his founding affidavit, the applicant says that the voters' roll that he got from ZEC is not the one that was used at the election. And yet he uses what he says is an incorrect voters' roll for the purposes of computing his figures and coming up with his numbers do not lie thesis. The third source, my lords, my ladies, is the Form V11 returns forms which have been collected by the contesting parties, primarily the MDC alliance. So they have collected this by whatever means, and this is what they give to the expert. Then the results announced and declared by the Zimbabwe Electoral Commission. And 5, the forms V23B returns collected by the polling agents and members of the MDC alliance and other parties. The integrity of the source of these figures cannot be vouched for. These are figures that have been created by an interested party from his own sources, which are not the official sources. From these, he alleges in the first instance that 700,000 votes were counted for. And the falsity of this is brought out by the first indication, which is that he uses a voter turnout of 72%. We know that the actual voter turnout, as declared by the 23rd respondent, was 85.1%. That explains what he calls unaccounted for 700,000 votes. He then says, in dealing with these figures, that there are other things that we must relate to. He says in Mashonaland Central, my lord, I would need more time, and I respectfully request that I perhaps be allowed another 15 minutes. Yes, the bell has just gone up.
Ah, all right, yes.
Indeed, my lord, I would need time, and also for my learned friend to relate to
How much time do you want?
Between the two of us, 30 minutes, my lord.
30?
Yes, my lord. I'm about to wind up, and my learned friend will deal with the other issues.
Well, we'll give you 20.
As it pleases, my lord.
Yes, you may proceed.
There is then the aspect of the 21% of V11s not.
You were addressing on the March Central?
Yes, March Central, my lord, where he says that about 105,000 people had voted by 6 p.m. He does not indicate at what time that compilation had been done. Was it done at 6 p.m. when the news reporter related to it? Was it done earlier on? But he omits to state that in Harare, where you won resoundingly, you had a similar trait. A certain number of votes declared by a certain time, and my learned friend Mr. Magwaliba will deal with that by specific reference to the record, and that these numbers shot up at the end. So that is not a basis. And then he goes on to what he calls unusual voting patterns. And the reasoning behind this is this. If people in Mavuku Tafara are subjected to the same conditions, live under the same conditions in respect, that is proximity in respect of space and time, then they would behave in the same fashion. And so he says that if 4 wards in Mavuku predominantly voted the MDC, it would be highly unusual for the 5th ward to vote ZANU-PF. Now let's assume theoretically, and this is hypothetically for the purposes of argument, that this is scientific. It is in fact not scientific. But let's assume that this is true. It would follow that if nationally, in the National House of Assembly elections, the parliamentary elections, you got no more than 30% of the vote, those very same people, subjected to the same conditions, would not have voted differently in the presidential election. So it means that in the presidential, he could not have gotten more than 30%. That is the fallacy and absurdity of the theory that has been put forward. It simply cannot stand. My learned friend, because he has no source documents, then related to the EU report as establishing that certain things were not done. And we make 2 points in respect of that report by the EU. The first is that it appears at record page 973. It was expunged from the record this morning because it was attached to the papers of the 20th respondent, Elton Stiers Mangoma. So the document he relies upon is actually not properly before the court. But in any event...
So which specific document is that?
The EU Observer Mission Report, my lady. That's at page 973. But then, again, as regards reports from international observers, our courts have already spoken that you still need direct evidence. You do not rely for the truthfulness of an occurrence on an observer's report. And that is the Buyera North Election Petition, 2001, Volume 1 of the Zimbabwe Law Reports at page 295. Pardon me, my lord. That's the Buyera North Election Petition, 2001, Volume 1, Zimbabwe Law Reports at page 295. And because what is alleged is so fundamental, the only available threshold of proof is that beyond a reasonable doubt. I'll add 2 authorities that are not in our heads of argument. The first is Mazoka and Mazoka and others versus Mwanawasa and others. This is the Supreme Court of Zambia Election Petition 1 of 2002. My lords, we also place reliance on Morgan and others versus Simpson and another, 1974, 3 all ER 722. In concluding, the aspects that I relate
if you
to...
could please repeat the citation.
Oh, my apologies, my lord. Morgan and others versus and another, 1974, Volume 3 of the All England Law Reports at page 722.
Is that citation, that authority part of your heads of argument?
It is not in our heads of argument.
Can you make it available?
Indeed, my lord.
Later. All right.
We will, my lord. I also noticed that my lord cited that authority in Moyo and another versus Zoma, which is where I actually picked it up from.
Just make it available.
As it pleases, my lord. So the rhetoric that numbers do not lie cannot be founded on numbers other than the official numbers. The only direct, clear, and admissible evidence that is before the court is that provided by ZEC. And that evidence shows a return of 50.67, which is above the required minimum threshold of 50% plus 1 vote. In the result, therefore, the numbers cannot be an issue. My lords, my ladies, I propose to hand over to my learned friend, Mr. Magwaliba, to deal with the rest of the issues that have been taken by the applicant.
Yes, thank you.
As it pleases the court.
You may take up the submissions, Mr. Magwaliba.
Court pleases. My lords, my ladies, the court is dealing with a grave matter. And because of its seriousness, this court has already held in Changirai versus Mugabe, an authority which my learned friend has already referred to at page 17, that it makes sense to require that this court has full knowledge of the facts before making a final and binding decision on the validity or invalidity of an election of a president. The intention was obviously to reduce the risk of an erroneous decision to a more tolerable minimum. Now, the applicant has made serious allegations of electoral malpractices. These have been directed to the first respondent, who is alleged to have colluded with the 23rd and 24th respondents. Those allegations, as my learned friend has established, must be established with reasonable doubt. Aware that there is a bundle of evidence which forms the backbone of the factual averments on which the applicant replies, which is not before the court. That has already been illustrated. We are also aware that there is an affidavit which relates to some of the aspects which the court is dealing with by one Tawanda Ralph Magunje, which is alleged to have been placed before this honorable court, and which the first respondent says he was not served with, and coincidentally, which the 23rd respondent also says was not served with, which was not served with the application. So the application is not regular. The application is not complete. The averments contained in the application cannot be sustained. Dear lordships and my ladies, we want to know that from paragraphs 133 to 153 of the applicant's heads of argument, those paragraphs deal with matters of fact contained in the additional bundle, which is not before the court and was never served on the respondents.
Can you come up with the paragraphs again?
133 to 153. How does the court relate to an incomplete application? How does the court relate to submissions which have been made based on evidence which has not been furnished to the respondents? How does that petition or application carry the relief that is sought? Certainly, my lords, my ladies, that cannot be. But let us relate, my lords and my ladies, to what are alleged as the specific instances of the violation of the law. The first such infraction is alleged to be a violation of section 61 subsection 4 of the Constitution of Zimbabwe. This is alleged against parties who are not before the court. ZBC is not before the court. The Chronicle, the Herald, which are owned, newspapers owned by Zim papers, are not before the court. Those newspapers have been vilified. Those newspapers have been condemned. And this court is expected to chastise the 23rd respondent for not taking action against those particular institutions. And yet, we do not even have one letter written by the applicant or his party to the 23rd respondent complaining about what he may have considered as skewed access to the media. But more fundamentally, there were internal remedies in terms of the Electoral Act. Section 28, Section 29, which the applicant could have resorted to. He could have filed a complaint. In fact, it's Section 160, I'm sorry, Section 160, capital letter K. He could have lodged a complaint with the Zimbabwe Media Commission he could have complained to the Broadcasting Authority of Zimbabwe. Both institutions are statutory institutions which are mandated to oversee the conduct of newspapers during elections. The applicant also is reticent about the private media, which is obligated again in terms of the Constitution under Section 1, paragraph D, to report fairly. He does that because he knows that the private media was in his favor. I quickly move, my lords and my ladies, to traditional leaders. No evidence whatsoever has been established. The court has been referred to some affidavit at page 77 of the record. They read some unnamed village heads are said to have marshaled the villagers to the polling stations. The polling stations mentioned there are 6. We are aware that there were 10,985 polling stations all across the country. What fraction, if at all, we were to accept that as a fact, would that constitute? Does that constitute an incident of such a widespread nature that it must vitiate the conduct of the elections in Zimbabwe? Certainly that cannot be. Rogue security elements, a bold and bare allegation is made that ZANU-PF and some rogue security elements were forcing villagers to vote for ZANU-PF. There is no name, no location, no date, no nothing. This application was not seriously made. The applicant is clearly flippant. The applicant makes serious allegations which are not backed by facts. The next question is SMS messages. The 23rd respondent denied that it gave any numbers to the first respondent or his party. At page 628, you have an affidavit, 628 of the record, in volume 2. You have an affidavit from one of the candidates in ZANU-PF, Mr. Haritatos, who says he got the numbers from his door-to-door campaigns.
Just hold on. Just hold on. What page is it?
628. That's a paragraph 7 at page 628, where Mr. Haritatos, who was cited in High Court proceedings, was defending himself, says, neither did I get any data from the first respondent. The party is privy to all my sales, my branch information that has been collected over the years from the constituency, even where it has records. They are from the constituency, for it is a party based from the grassroots. So this is the evidence on oath from the party which the first respondent relates to. In his answering affidavit, the applicant simply says the only place that you could have ever gotten that information from is the 23rd respondent. And that is the basis of an allegation of collusion by the first respondent with the 23rd respondent in order for the first respondent to benefit. That cannot be a serious allegation. That cannot be an accusation of an electoral malpractice. That cannot be foundation for this court to find that the playing field was not even. The question of the voters' roll has been sufficiently related to in the response of the 23rd respondent. I will not deal with that issue to any great detail. I would only wish to submit that it is alleged that 11% non-existent voters appeared on the voters' roll. That figure has no foundation, no study of the voters' roll, no audit of the voters' roll. Zimbabwe Electoral Support Network, which audited the voters' roll, does not support that figure. So the court is expected to rely on the supposed breaches, which have no empirical foundation. Partisan clothing, Again, because an allegation of collusion is made, becomes very central. But this application, if it were seriously made, cannot be about scuffs. We all know that the 30th of July as the date of elections was proclaimed on the 30th of May 2018. On the 5th of February 2018, when the 24th respondent put on that scarf, there was no candidate. But in order for the applicant to make out an appearance of a case, he will grab at everything and anything. My ladies, my lords, the question of ballot stuffing in relation to voter education, the applicant does not deny the fact that all parties during the meetings of the multi-party liaison committee were given sample ballots which were marked in bold samples. Those were photocopied by ZANU-PF, the party of the first respondent, and used for purposes of voter education. The applicant proceeds from a wrong premise that a political party cannot conduct voter education. Yet section 40, capital letter C, subsection 1, permits a political party to do so. Again, there is no established infraction of the law. The design of the ballot paper has been subject to judicial determination in the High Court. Case number EC 09 of 2018, Progressive Democratic Party versus ZEC. This court is not sitting as an appeal to review that judgment or set it aside. But yet, same and similar allegations are made in respect of the design of the ballot. But what is also significant is the fact that the applicant does not say how many votes he lost as a result of the design of the ballot, because he lost none. So again, this feeds into the numbers don't lie theory. If the facts are wrong, the numbers will be wrong. They will give you an erroneous result. The posting of V11 forms, the court has already engaged with the applicant's counsel in relation to that. There is some unfounded suggestion that 21% of the polling stations did not post V11 forms at the end of polling. That is a figment of the applicant's imagination. It has not been established. The question of the postal ballots, again, the indeterminate affidavit of Sweden Chiroza at page 111 of the record is relied upon by the applicant. A judgment in relation to the postal votes was handed down by the High Court in Mutare. We refer to it in our heads of argument, and I will not spend time on it. The question of the disenfranchisement of civil servants, the 40,000, no one knows if those 40,000 indeed exist. No voter came to court and said, I was disenfranchised. The teachers' unions came and spoke for persons who did not complain. So the 40,000 is an estimation. In fact, the two teachers' unions are at variance. One of them says it's 40,000, the other says it's 60,000, if you consider carefully their affidavits. The question of undue influence. In fact, before I move from that point, my ladies, my lords, it is opposite that I refer to the judgment which we refer to in our heads of argument at page 37 in paragraph 46.2, which is the judgment of Emmanuel versus Umana, which we have already referred to in the same judgment, which states that it is no longer open to any disputation, that this court has consistently maintained that in order to prove disenfranchisement, a petitioner must scale the Trinitarian test, enunciated in such cases like Ngige versus INEC 2015 1 NWR 281. In effect, such petitioner should summon disenfranchised voters from each polling unit or booth or station to testify. We indeed do not have such kind of evidence. I was going to move quickly, my lords and my ladies, to the question of undue influence. I wish to prefix this submission with the fact that in terms of the Electoral Act, Section 171, subsection 2, where it is established that a vote was obtained through undue influence or other improper means, that specific vote will be deducted from the candidate. And that's very important. So the onus upon the applicant is not general, it is specific. If he wishes to discount any vote which was declared in favor of the first respondent, he must justify the deduction of each of those votes. And that onus does not shift, as my learned friend submits. It is his case. He must prove it. He has not proven it. The applicant relies on statistical information from an individual, we argue and submit, who is in fact not an expert at all in elections, in electoral matters. Why should the court relate to that affidavit of the so-called expert? He has studied fish migration. He has conducted an audit of the election of a sugar board in 2000 and presents that as the basis of his opinion. More than that, he files an answering affidavit after his postulations have been proven wrong. He pitches camp with the applicant. That shows that Dr. Otumba is not an expert who is neutral, who can shed light to the matters that are before the court in a colorless and objective fashion, and he indeed failed to do so. My lords, my ladies, the procedure at polling in terms of the counting is related to properly in the papers before you. The first respondent's polling agent, Ziyambi, placed an affidavit at page 432, which is in the first volume, which is very clear as to what happens at the end of polling. In order for that to be refuted, the applicant needed to go to the primary evidence. He has deliberately chosen not to lead primary evidence of the ballots. He fears what is inside the ballots. He calls it poisoned chalice. He has no evidence to prove that there is any poison in the ballot boxes, and therefore he is bound to his petard. The allegation of bribery, my lords, my lady, has not been established at all. In the final analysis, it is correct to submit that the allegations of constitutional and statutory infractions have not been established. In the Changirai versus Mugabe judgment, His Lordship, the Chief Justice, then as the Deputy Chief Justice, postulated a two-stage inquiry. Did the allegations, did the facts alleged in fact occur? If they are established to have occurred, you go to the second stage. Did they materially affect the outcome of the poll? I submit that in the present matter, the first inquiry has not been passed by the applicant. The facts alleged have not been established to have occurred. It is therefore not necessary to relate to the second. But if it is necessary, again, those little isolated incidents, if ever the court finds any evidence of them, are not material to warrant the upturning of the declaration of the first respondent. Let me quickly answer to the submissions of the applicant in relation to the preliminary points. The Constitution states that the application of this nature must be filed within 7 days. The applicant was conscious of that. He was not only conscious of the fact that the application must be filed within 7 days, he was also conscious of the fact that it should have been saved upon a proper interpretation of the Constitution within 7 days. That is why he attempted to ensure that service was going to be effected within the 7 days. We all know that he did not succeed. He chooses to blame the sheriff. But the court documents delivered to the first respondent show that they were received by the sheriff on the 11th. They were not received on the 10th. So, my lord, if I may wind up in 2-3 minutes.
How many minutes?
2 or 3 minutes? 3 minutes?
All right.
5 minutes. The rules in Rule 3, 9, sub-Rule 3, provide what happens if it is, if a party encounters a difficulty in serving. They provide that the party approaches the registrar and applies urgently for an alternative means of serving. The applicant did not avail himself of that remedy. And I submit that if you read all the rules together with the Constitution, there is no doubt that the period of 7 days does not include weekends. That would lead to an absurdity. There would be no period within which an application such as this would be served, because the court would have ignored Rule 23. My lords, my ladies, it is my submission in the circumstances, therefore, we do not abandon all the preliminary points. As per our heads of argument, we will abide in all respects with those preliminary points as they are in the heads of argument. It is our prayer that the applicant has not established either the main relief which he seeks or even the alternative relief. At the end of this hearing, at the end of the submissions by the applicant, no one knows how many votes he says should be discounted from the first respondent. The calculations which we were taken through are not in the founding affidavit. They are purely extrapolations, and they cannot found or yield a judgment in favor of the applicant. Those are my submissions for the first respondent.
Mr. Magwaliba, what about the argument put forward by Mr. Mpofu that, on behalf of the applicant, that Section 93 of the Constitution necessarily, once an application has been lodged, it necessarily invokes the jurisdiction of the court, and that rules of court cannot deviate from that? In any event, you can deal with the second aspect as well. If there has been a breach of the rules, they have sought condemnation on the basis that the failure to serve was due to the sheriff's failure to comply with an undertaking to serve by the end of the day on the 10th of August.
Our submission, my lord, is that the requirement to serve the application does not derive from the rules read in isolation. It is derived from the Constitution. The legislature deliberately used the word lodge. It did not use the word file. The rules then give life to that word by defining it as filing and serving within 7 days, the same period. And Rule 3, Sub-Rule 2, says unless a contrary intention appears, then weekends and public holidays will not be counted. And it is our submission that a contrary intention appears in Section 93. A contrary intention appears from Section 94. These proceedings must be resolved within 14 days. The president, once elected, must be sworn in within 9 days. The Constitution does not say court days, does not say business days. It simply says days. And the intention of the Constitution is to ensure that constitutional disputes relating to the appointment or election of a president are resolved in the shortest possible time. And the precedent which will be set will be that once the court finds that there is no requirement to serve within 7 days, an applicant or petitioner would file the petition and be at latitude to serve after 3 days. That is into the 14 days.
Well, it's in agreement with you. It would probably squeeze the period for serving opposing affidavits and answering affidavits into an even shorter period if the time after the 7th day were to be extended to include provision for service on non-respondents.
That is correct, my lord. And the question also in this case is, why did the applicant wait until the final day at 4 p.m. to file? He had 7 days to act. He should have acted.
You've not dealt with the application for condonation.
My Lord, the application
Maybe
for
before you do
condonation...
that, Mr. Magwaliba, maybe before you do that, can I refer you to section 169 of the Electoral Act and see if you can address us on whether that is applicable or not to a presidential election?
As you please, my learned friend will take that point.
Section 169 is read with the interpretation in 166, which includes the president as a respondent.
Yes, my lady.
Hold on. There are now 2 questions. Can we first deal with the first question by Justice Patel had not been completed? Deal with that and then come to the second question so that we don't confuse the answers.
As you please, my Lord. My Lord, if I may get the complete question.
The application for condonation.
The application for condonation.
The argument is that it is in the interests of justice that it be granted.
Thank you, my Lord.
And that there are reasons why there was late filing.
My Lord, the reasons given for non-compliance are patently deficient. As I've indicated, Rule 9, Sub-Rule 3 provides a remedy which the applicant could have resorted to if he were minded to have a relaxation ahead. He did not. Secondly, as I've just submitted, there is no explanation for the delay to wait and file only at 4 p.m. on the last day, well knowing that there was going to be need to serve. So the application is not bona fide at all, and it cannot be granted. In fact, their lordships and my ladies will notice that there was service by the legal practitioners for the applicant, completely in breach of the rules which say initiating process should have been served by the sheriff. There's no good explanation for non-compliance with the rules. But in the main, we submit that a breach of the Constitution cannot be condoned by the court. But if the court finds that that requirement arises from the rules as opposed to the Constitution, then condonation would be an issue.
Thank you. You can now answer the question by Makrauji.
Thank you, Chief Justice. My lady, we submit that Section 160 of the Electoral Act 169 does not apply to a construction of Section 93 of the Constitution. This, my lords, my ladies, is because Section 93 is introduced by a non-obstante clause subject to this section. What that means is that any other provision of our statutory law or the rules must be subjected to Section 93. And in looking at Section 93, we must look at the purpose for which Section 93 was enacted. It was enacted in the manner it was enacted to afford an aggrieved party an opportunity to challenge an election result, but bearing in mind that the office of the President of the Republic is a cardinal office and any disputation in relation thereto must be resolved as soon as possible. Now, there are 2 essential elements under Section 93. The first is that the application must be lodged within 7 days, and that is peremptory. And we submit that lodge means file and serve. And then the second is that this court must hear and determine the application within 19 days after, 14 days after the application was lodged. Now, if we are going to apply Section 169, an absurdity so glaring that the legislature never intended would arise. That section provides for service within 10 days of the presentation of the petition. My lady, that would mean that a mala fide applicant will lodge the application with the registrar on day number 10 and does not serve for another 10 days, which would leave this court with just 4 days to hear and determine the matter. But there is yet another problem. It is the service of the process that kicks in the DS Induke. Without service of the process, the DS does not begin to run. It would therefore mean that from day 10, if we're going to relate to that section, the respondents then have the 3 days that were put in the notice of motion to file their opposing papers, and this court cannot sit beyond the 14 days. It must obey the constitutional prescription to hear and determine the matter within 14 days. But matters go beyond that. And the ordinary rules of motion will then give the respondent 10 days within which to react to the application, which takes us way out of the 14-day period.
Well, clearly it seems that the Act has not been, in this respect, has not been aligned to the Constitution.
That is the point that we make, my Lord, and that it is clearly not applicable to a construction of Section 193. And the framers of the rules were alive of the need to subject all procedures to Section 93. That is why Rule 23 gives meaning to the word lodge as used in Section 93. It says, you shall file and serve. And that service requirement within the 7 days we submit is by constitutional prescription, breach of which cannot be condoned. My ladies, my lords, we submit on the authority of the Ngazimbi case that we have related to in our heads of arguments, that what entrenches valid process is the issue and service within the prescribed time. Those will be our brief responses to my lady's queries, my lady.
Yes, maybe I missed it during your address, or perhaps Mr. Magwali, you've assisted voters that in light of what is alleged.
Yes, my lady, that is addressed in our heads of argument with which we abide. The position we take is simply this: the law of Zimbabwe allows for voters to be assisted, and to be assisted by persons of their choice. There is no evidence whatsoever on record that shows that people were coerced into being assisted. The alleged percentages themselves are not founded on any facts. These are just pulled out of the air. Where does he get the percentages from? He does not relate to a source document. He does not relate to any factual basis. He has this tendency in his founding affidavit of relating as common cause to matters which are clearly in dispute. But the onus was on him to establish by clear proof that there was coercion. To establish by clear proof how many votes these were. To establish what effect these would have had on the final result were they to be discounted. There is absolutely nothing on record to ever think that that allegation is a basis upon which the election of the first respondent as the President of the Republic of Zimbabwe can be vacated.
There's also a suggestion, Mr. Uriri, that in some instances more people voted than were registered on the roll for that particular polling station.
That, my lord, has not been established by any evidence. What the applicant would have had to do is to produce a copy of the voter's roll in respect of the polling station to which he relates to. And that copy, as used at the election, is available as part of the election residue that is sealed and preserved under Section 70. Secondly, you'd then have had to show that this particular number of ballots was cast. And there is only one way of showing the number of votes that was cast, that were cast, and that is by reference to the V11s. What you have are figures that feature mysteriously in the report of the expert, figures whose source of origin is unknown. That allegation, my lords, my ladies, has not been established by reference to evidence that can be related to by the application of the competent rules of analysis.
Mr. Uriri, would you like to comment on the submissions made by Mr. Mpofu, or rather I would leave it for the 23rd respondent, that this election cannot stand on the basis that of ZEC's own results. So far it has 3 sets of results.
I'll answer that question as best as I can by reference to, I'll just make 2 submissions in answer. The first is that ZEC's results are the official results, and the figure they've given us of 50.67 is the figure. The declaration under Section 110 is the declaration of the winner. That is what can be set aside by the order of court. The expressio unis rule would then kick into play. Express mention of the declaration to the exclusion of a correction of the numbers means that what is proscribed by statute is for ZEC to change and say it was a different person that was declared. That requires an order of court. But its numbers, for as long as they do not change the minimum threshold of 50% plus 1 vote, would stand. The second answer I'll give, my lady, to your question is by simply relating to the judgment of the U.S. Supreme Court in Bush versus Gore. My lady, in Bush versus Gore, the numbers kept changing. But the court was of the view that unless it was shown that this had the effect of changing what would have been a true reflection of the will of the people, the court can only exercise oversight. And my lord, the Chief Justice, then DC, the Deputy Chief Justice, relates to that judgment in the Changirai versus Mugabe judgment, CCZ 20 of 17. At the end of the day, the question is whether the election results were arrived at in a manner that complies with the law and reflected the free electoral will of the people of Zimbabwe. If it did so, 1, 2, or 3 immaterial mathematical errors will not change the fundamental premise of a due return that is envisaged by Section 93. Indeed, in Payo versus Smith, which is a judgment of our courts that closely mirrors even the passage in our heads of argument that relates to the Museveni judgment also appears in Pio versus Smith. And in Pio versus Smith, the victor won by 3 votes. That is all that is required. We have dealt with that, my Lord, to the extent that we could. Strictly speaking, that's a matter for the 23rd respondent, but we just wanted to highlight that even in one of the jurisdictions that is said to be one of the most progressive on earth, a change in the figures in Bush versus Gore did not invalidate the result.
Thank you very much, Mr. Uriri. We have come to the end of submissions for the first respondent. Before we go to submissions on behalf of the other respondents, we'll just take a health break. 10. Yes, but we'll take 10 minutes just to get a health break. The court
but I know me. I want to some glass. I want it. Then we put.
Take positions. Take positions. Take positions. I'm going to call the judges.
Yebo kambe umthakazo omhle siqhubekela phambili silipha ke kwenzakala ngapha esigodlweni yaRara idale le-Constitutional Court admire tukuenderera mberi tikupa ikavanhu kumba zviri kuitika kuno kudare re-Constitutional Court regai tipinde mukati.
May it please the court resume the matter adjourned.
Yes, we will proceed with the hearing of the matter. We will now give the opportunity to Mr. Kanengoni for the last three respondents.
Thank you, my Lord Chief Justice. My Lord, I understand counsel for the first respondent had wanted to hand in an authority that he had indicated he would hand in. Perhaps if you could do that before I begin.
See, they will do that later.
Thank you, my Lord Chief Justice.
Proceed. Yeah.
My lords and my ladies, what you have before you is a matter that has been brought on notice of motion by an applicant challenging the election return for the presidential election, the 2018 presidential election. That matter, in terms of the rules of court, is initiated by an application, the parameters for which are prescribed in the rules of court, and I will relate to those shortly. But firstly, what I wish to point out is that in a matter such as this, the onus rests, lies, and must be borne entirely by the applicant. He must, in his founding papers, place before the court enough vehemence, with enough clarity, with enough particularity, and enough evidence to establish his cause. He cannot, with respect, rely as a basis for his matter on the responses by the respondents. His case must stand, or it must fall, by the papers that he files. Having said that, my lords and my ladies, it is now common cause before you that there is part of this application which is neither before the court nor was served on any of the respondents in this matter. Part of that application was by some means attempted to be smuggled in through some of the other respondents who attached certain bundles that were not served on anyone, but those have been expunged from the record. They cannot have any moment in the determination of this matter, and no argument can arise from them. Now, the first point that I wish to put across relates to the point in limine that is taken on behalf of the 23rd, 24th, and 25th respondents. It relates to whether there is, in fact, a challenge to the presidential election results before the court, validly filed in terms of the Constitution, Section 93, as read with the relevant provisions of the rules. That would be Rule 23 of the Constitutional Court rules. The point that we make, and we make it in our heads of argument as well as in the opposing affidavit, is simply this. An applicant seeking to rely on the provisions of Section 93 of the Constitution is now bound by the rules of this Honorable Court, in particular Rule 23, in the manner in which those provisions are given effect. We submit, my lords and my ladies, that the meaning of the rules, particularly Rule 23, is such that the definition of lodging as it arises in the Constitution is given particularity and color by the provisions of Rule 23. To that end, essentially, a party lodges a challenge to a presidential election return by filing and serving through the Sheriff of Zimbabwe his papers. Now, these dictates are peremptory. They cannot be deviated from by an applicant who wishes to have a valid application before the court. Now, the facts that are common cause before you are that there was an application that was issued with the registrar on the 10th of August, which was the 7th day. That application was not complete, as it has several things that are missing, both from the records of the court and the papers that were served on the respondents. And that service by the sheriff only occurred on the 11th of August, which is the 8th day after the declaration of the result. Now, that is in itself outside the parameters of the rules. So already the test for whether something was lodged has not been met by the applicants in this matter. There was an attempt with respect to the 23rd, 24th, and 25th respondents to serve papers on the 10th of August through the applicant's legal practitioners without the assistance of the sheriff. Now, what they served was a single copy of a bundle. Now, within that bundle was absent a very crucial document, that is CCZ1, the form of a court application before this honorable court. So even upon the service that they tried to effect on the Friday, they actually did not serve anything. What they served was an index, some addresses of service, a founding affidavit, and some annexures that were physically bound to it. Even the separate bundle that they say they had on that Friday, which one assumes would have easily been able to serve on respondents themselves if they thought that was proper, they did not even bring that. Even on the 11th, that was not brought by the sheriff. The net effect of this, my lords and my ladies, is that there effectively is no validly filed challenge in terms of Section 93 of the Constitution before you. The jurisdiction of the court has not been properly invoked in this matter, and the correlative finding in the Trangirai versus Mugabe matter that the court, once seized with a duly lodged petition or application, must deal with it on the merits, does not, in our respectful submission, arise in this matter. It would only arise if we had something valid before you. You do not have something valid before you. That is the point that we take first in limine. And the result of that point would be that the matter, if the point is upheld, be struck off the roll. And we accordingly pray. Now, in the format that the proceedings are taking, we move on to the merits of the matter. And in dealing with the merits, we will start with the question of figures, because it appears that that is where the applicant takes greatest issue with the 23rd respondent. The applicant in this respect relies upon Annexure Z, which is part of the 4th volume. It is an annexure that was filed by the Zimbabwe Electoral Commission, and it is a statistical report analyzing the...
Sorry, annexure what?
Which volume is it? Volume 4?
It is the 4th volume, Annexure Z.
All right. Yes.
Thank you, my Lord Chief Justice. Now, Annexure Z is a statistical report that was prepared in response to the petition that was filed by the applicant, which itself had its own expert reports attached to it. which curiously the applicant does not seem to rely on anymore, but prefers to rely on the respondent's papers now. Now, the court has been referred in that particular document to paragraph 1.5, which appears in the numbering that I have here at page 19. I don't know if all members of the court have...
What paragraph?
Paragraph 1.5.
125.
1.5. Perhaps if the court can look at the bottom of those pages, it is printed page 4 of 10. Perhaps that could assist the court. Annexure Z.
Z?
Yes.
Yeah. All right. Yes, we are at it.
Thank you, my lord. Now, my lord, the court has been referred to paragraph 1.5 of that annexure. And paragraph 1.5 has been characterized by the applicant as the analysis of a single aspect of the election results, which produces a variance of 4,491 with respect to the applicant and 4,453 with respect to the respondents, to the first respondent. Now, that is a mischaracterization of this report. Now, the sequential logic of this document. Beg your pardon, my lord? My lord, in paragraph 1.5, it is recorded that there is a variance with respect to the applicant of 4,491, and that there is a variance with respect to the first respondent of 4,453. And those figures are presented by the applicant as being an analysis of one aspect of the presidential election results, one error in the presidential election results, which should be added to others to give some cumulative figure. Now, the point we make is that this report has been mischaracterized by the applicant in that respect. If you look at the sequential logic of the document, I will take you just to the previous page, the page immediately preceding the one we are on now. You will note that it starts with an introduction. It then goes to the data sources that were used, the methodology that was used, and the findings on the data quality, where it lists the clerical data capture errors that were identified. It then goes to paragraph 1.5 overleaf and gives a summation of the net effect of all of that upon the results. It does not give a single item. This is all of it. And it amounts to 0.1% in the grander scheme of things. Now, the applicant then took the court to paragraph 1.64.
Sorry, 0.1 or 0.01?
1.6.4.
What is the error margin? Is it 0.1% or 0.01%?
Oh, I beg your pardon, I hadn't really understood. It was 0.1%. Now, the applicant then took the court to paragraph 1.6.4, which is titled Double Counting of Polling Stations, and the table overleaf, and indicated that the figures that are represented thereon should be added to those that are found in paragraph 1.5 to increase the variance in the votes between the applicant and the first respondent. Now again, if you look at the sequential logic of this document, what appears under paragraph 1.6.4 are now the itemized evaluations or assessments by the statisticians of the net errors that are represented in paragraph 1.5. So what is in 1.6.4 has already been taken into account in coming up with the conclusion that is found in paragraph 1.5 of this document. What am I saying? The simple point I am making, my lords and my ladies, is this. The entire variance, all of it, everything taken into account, all clerical errors considered, is represented in 1.5. No one should go ahead and start adding anything that appears after paragraph 1.5. Therefore, it is a mischaracterization of this report by the applicant to say it proves that more than 16,000 or 18,000 votes are unaccounted for in some respect. The only variance that is discovered by this report appears in section 1.5. That is the total, and it includes everything. Now, the applicant then relates to a question of civil servants and indicates that at least, or it is not even stated as at least, it is stated as a fact that 40,000 did not vote. And therefore, we should add that 40,000 to whatever that he has found in Annexure Z, and that the threshold for overturning the election return has been found. But with all due respect, my lords and my ladies, that 40,000 arises from nowhere. Literally nowhere. There are affidavits that are filed with the application which purport to state that there is a population of teachers or civil servants that did not manage to vote on polling day, which amounts to 40,000. Those affidavits, with due respect, have no empirical analysis that they spell out. They spell out no basis upon which the 40,000 is reached. And with all due respect, there is not even an indication whether all the teachers that were seconded to ZEG were in fact registered voters. These are all variables that are not accounted for in the assumptions that the applicant makes. It is not even indicated whether of these 40,000, how they can be attributed to the applicant. To say, from 40,000, I would have gotten X amount, therefore I should have been declared the winner of this election if it were not for ZEG's actions of disenfranchisement. We all know that we work from a system of a secret ballot. There is no way that the applicant can divine what those 40,000, if we assume that they exist, or who they would have voted for. It is unknown. Now, my lords and my ladies, that 40,000 should not be factored into any computation that this court takes into account. It has not been established by evidence. It has simply been thrown around as a figure that exists. And it is contrary to evidence that has been produced by the 23rd respondent before this court in terms of Annexure X and Annexure Y of the fourth bundle of documents, which is Annexure X has affidavits from civil servants who confirm that contrary to the applicant's averments, the Electoral Commission did in fact facilitate their right to vote, and Annexure Y contains self-made declarations by persons who wanted to be seconded to ZEC, who indicated that if it is not possible for me to vote, I would rather be seconded than go and vote. That was a free choice that they made, consistent with the Constitution, because no one is forced to vote. Now, in the light of that evidence, there is no basis, either in probability or beyond a reasonable doubt, to assume that the Electoral Commission conducted some form of a systematic disenfranchisement of civil servants. If anything, the evidence that is before you indicates that the Electoral Commission did all that it could and all that it had to do to facilitate the voting by civil servants. The 40,000 is out. The applicant, again, though they do not specify it in their oral submissions before you, in their papers they make reference to a figure of 700,000, which they indicate as unknown or unaccounted for voters. This is how they arrive at that figure. They take the total voter population, they apply a voter turnout of 72%, and then they say those that should have voted then are X number, but those that voted are Y number. They subtract X from Y and come up with 700,000. Here's the problem with their analysis. Firstly, it is based on a wrong voter population. Secondly, it is based on the wrong voter turnout. The turnout was 85.1%, not 72% as they submit before the court. Now, if the math is done, and we do so in the opposing affidavit, if the math is done using the correct voter population and using the correct voter turnout, one will find that there is no discrepancy between what was announced as the number of voters that came out and what is indicated as the voter turnout as juxtaposed with the total voter population. The 700,000 is fully accounted for by their error of using the wrong voter turnout and the wrong voter population. So the 700,000 is out. So already most of the figures, if not all of the figures that they presented before you as the irrefutable empirical proof that there was an inflation of figures or a rigging of the election, have already been chucked out. There is no evidence for them. There is no basis for them. They are based on a wrong analysis of the documents before the court. But then we go further. They say there are polling stations where voters in excess of the voter population voted. They put that in what they call the G series that they attach to the founding papers. That is completely false. And we say as much in the opposing affidavits. The reason we say so is quite simple. We don't know where they get their data. We don't know how they compiled their data and how they did their comparisons. But on the data that the Electoral Commission has, which incidentally is the custodian at law of all voters' rolls and of all the voter residue and statistics for the election, the information that we have, which we have placed before the court in Annexure V, which is again part of the fourth bundle, indicates that there is no polling station of the ones that they identify in the founding papers that represents overvoting. Now, I would wish to take the
Sorry,
court...
could you just repeat that? Last submission.
I will take it again, my lord. The point has been made by the applicants that there were certain polling stations where the number of people who voted was in excess of the number of registered voters. And we've identified the annexure that they put in, which they seek to use as proof. That's Annexure G. We have put in Annexure V, which is part of the 4th volume before the court. That Annexure V has the actual V11 forms for these polling stations, and for each province has a schedule that then indicates the Zimbabwe Electoral Commission's own verification of the claims made by the applicants by the applicant in his papers, and debunks them. Of all the polling stations that he cites in his papers as having overvoted, none were found to have overvoted. I was then moving to try and take the court through just one province out of Annexure V for purposes of illustration. That would be Mashonaland East. I don't know if the court has found Annexure V, but essentially what Annexure V does is that V. Yes. I think it's the one that's a bit long.
Sorry, B or V?
V.
B.
V. Yes. I think my lords and my ladies, the one that's a bit, it's more than A, it's A3, I think. The one with the V11s. Thank you, my lord. Now, if you go to the first page of that annexure, there is a schedule there that is indicated Mashonaland East. It lists all the polling stations in Mashonaland East that the applicant, in his application, alleges overvoted. And in the fourth, I think it's the 5th, 6th, and 7th columns, we record what the applicant says in his application, the total of votes, the registered voters, and what he alleges as exceeded voters. And then in the last 3 sections, columns rather, the highlighted ones, ZEC then does its own verification, and in the last column shows that no excess voting happened. And as proof of that, ZEC then attaches the V11 forms with respect to each of those polling stations in 10 to show that there was no overvoting as the applicant alleges. This is done throughout Annexure V for various provinces that arise from the applicant's Annexure G. So that is the illustration that is made by the Electoral Commission through Annexure V, which effectively and conclusively puts to rest the issue of overvoting at any polling stations, because these are the polling stations that he identified. We have produced the V11s to show that this did not happen. But more importantly, my lords and my ladies, the allegation of overvoting is simply made. It's not linked to the result. There is the bold allegation that this was fertile ground for rigging. There is no particularity about how this rigging is said to have happened, in what manner and on whose behalf and through whose agency. The applicant does not say, please open the ballot box for polling station X so that I can show you that what is in the ballot box is in excess of what is on the voter's roll. Doesn't do that. He simply makes his allegation in his papers very bold through a schedule that is not V11s, does not attach any V11s to his papers in this respect. Therefore, he fails to meet the standard of proof on that score. He fails to put himself in the confidence of the court to say, what I am saying is the correct thing, and what ZEC is saying is the wrong thing. But how can you say what ZEC is saying is wrong when ZEC gives you the V11, the primary data that produces the return for that polling station, and you produce nothing? On what basis can we weigh your contentions against ZEC's and say your contentions must succeed when ZEC produces the real things, the real documents, and you produce nothing? And when you are asked, why did you not produce these things, you say, it was not up to me. But as I stated at the beginning of my address, this is a procedure under a notice of motion. You must give us all the evidence. The onus is on you. If you say there was overvoting, prove it. If we give you evidence to disprove it, you cannot then say, well, I still have some issues with ZEC. Produce the evidence and debunk what ZEC has given you. They have not done so. They have simply come to court and cried wolf and said there was overvoting with no evidence. Now, there is further allegation by the applicants that there was a forging of V11 forms in some respect to try, as they allege, to rig the election. There's again no particularity as to how exactly this is said to have arisen, and they place before the court an affidavit which they indicate, I believe it is the affidavit of Joseph Madzudzo, which appears at page 120 of the first volume. And in their submissions, they say ZEC has done nothing to... my Lord...
yes, just hold on. Yes. Just hold on a moment. I think you referred to volume?
First volume.
Volume 1.
At page 120.
Yes. Yes, we are there. How many more minutes would you want?
Perhaps I could get 15.
Sorry?
15 minutes.
15, all right, we'll give you 15.
Thank you, my Lord. Now, the affidavit of Joseph Madzudzo is presented as evidence that there was forging of V11s after the fact by the Electoral Commission. And the allegation is made, or was made in oral submissions, that ZEC has done nothing to answer that. Now, with all due respect, ZEC has answered that fully. If one goes to the second volume at page 737, you will find...
What page?
That's the second volume, page 737. Yes, the court will find there the affidavit of Mnyaradzi Msodza, who is accused by Joseph Madzudzo of having done the forgery on the V11. He clearly refutes for Makosa Primary School. But if one considers that V11, you will see that it is incomplete because the applicant put it in the application in an incomplete form. We have put the complete V11 in our opposing papers. It appears in volume 2 from page 732 to page 735. And I will endeavor to explain page 732 to page 735. Now, let me just explain this. If the court is there with me now.
So, Mr. Chairman, is that the one with Mapengula tent?
No, it's in volume 2 at page 732. It's written Makosa Primary. Yes, Makosa Primary.
We have different pages.
The unfortunate thing is that this does not have, unlike affidavits, it doesn't have paragraphs and so on. I don't know if the rest of the members of the court have managed to find it.
It appears our record has some missing pages. From 712, we go to page 770.
Oh, it skips all those pages. Perhaps, my lords and my ladies, I could just take you through the explanation that I...
Perhaps you could indicate
we don't seem to have the annexure, annexure 2. We don't have annexure 2. We have annexure 1 at page 726, 739.
Yes, that's where...
Is Makosa School in Mutoko, RDC?
Yes, exactly. That's the one.
So that's the one on page 739.
It's now at apparently page 739.
Ah, okay. So I think there's just a difference in pagination there.
Yeah, different pages. But anyway, we have got the page that you are, the document that you are
that I'm
referring to. You may proceed.
Thank you, Chief Justice. Now, what appears at page 739 is what has been attached to the application. And you will see that in section, what is labeled section B there, which is the ballot paper account before poll, there is indication of a table which has the numbers of the ballot books that have been delivered at the polling station. You will note that the printed numbers are cancelled out, and then there is the inscription of 13 to 21 in longhand. If you go to the next page, you will find that there is now the first page of that V11, which records ballot book 1 to 12. 12 being the maximum number of ballot books that can be recorded in that table. If you then go to the next page, you will find the results for that polling station. They are duly recorded. And then if you go to the next page, you will find the signatures of the various polling agents, including 2 MDC Alliance polling agents. The applicant seeks to give the impression to this court that what appears at 739 is a single document that has no other accompaniment to it in the form of results, and therefore is just a blank V11. What is clearly illustrated by the full V11 is simply this. A polling officer records all the ballot books he has, 1 to 12. If they exceed 12, he takes another V11 and records 13 to 21, as he did, and he attaches it all together. He then records the results on the V11 that has book 1 to book 12. And so if someone, by mischief, removes the second V11 that's been attached, which has book 13 to 21, they can present it as if it is a V11.
That is very important, Mr. Kanengoni. Can you go over it again slowly, please?
Thank you, my Lord Chief Justice. I indicated that what is reflected on page 739 is a V11 with a ballot paper account, essentially. And you will note that the V11 gives allowance to record the numbers of the ballot books that have been received at a polling station. The one that is at 739 has the printed numbers cancelled out, and you have numbers indicated in longhand from 13 to 21. If you then go to the next page, which in the court's records should be 740, you will find that there is recorded there the ballot books from number 1 to number 12. And at the next page, the results for the polling station are recorded. And on the next page, the signatures of the polling agents are endorsed, including 2 MDC Alliance agents. The point we illustrate through this annexure is that the applicant simply took what is on page 739 and presented it to the court as if it is a V11 that does not have correlative results for a polling station and therefore is blank.
Because of the different page numbers which we appear to have, perhaps you can indicate the particular form you are referring to. Because one form refers to book 1 to 12, and the other one refers to books 13 to 21. You are referring to which one?
The one that only has section B on it, appearing at 739 if your record is similar to the Lord Chief Justice's.
No, it's not.
It's not. The one that has the book 13 to 21 written in longhand.
Yes.
Thank you. Quote by the applicant, and he says it is orphaned. It has no results attaching to it. It is blank. It is signed but blank, and therefore was used for rigging. The explanation we give is very simple. A polling officer must record all the ballot books he receives at the beginning of the poll. to book number 12. And record from 13 to whatever number the books end. In this instance, they ended at 21. He will then attach that second V11 to the first one, such that they become one record. And at the end of counting, he will endorse on the first V11 the results of the poll. The second V11 will therefore only have the number of the ballot books that we received. So if someone were to take the second V11 attached, remove it from the first one which has the results, he could confidently present it before the court and say, well, look at this V11, it is orphaned, it has no results, it is blank. That's what the applicant has done. And where full V11 is available, we have illustrated that the applicants claim that such V11s were blank V11s and were used for what he alleges as rigging. His claim in that respect is false and disproved. I don't know if I've managed to explain the document fully.
Yes, you have. We are following what you are saying.
Thank you, Lord
You may
Chief Justice.
proceed.
Now, again, on the question of these numbers, the applicant says there is an unreasonably large number of people that were assisted to vote. Now, the simple answer to that is that the Electoral Commission does not endeavor to inquire into the reasons why a voter elects to be assisted. The Electoral Commission, by peremptory dictate of the law, must allow a voter to be assisted once they indicate that they want to be assisted. That is not a malpractice on the part of the Electoral Commission. In fact, the opposite would be a malpractice if the Commission were to deny a request to be assisted by a voter. So the number which they characterize as unusual of people who are assisted to vote really does not find its way to the Commission as a basis to say there was something nefarious that the Commission was doing. The Commission has no control over that. The Commission simply accedes to the requests and allows the voting to happen. And in this respect, the allegation is again not linked to the result. It is not linked to the return. It is not linked to the votes. It is not linked to the request to overturn the election in any particularity. It is simply thrown in to cast aspersions on the conduct of the Electoral Commission. There is no affidavit from any voter alleging coercion to be assisted to vote, and more particularly alleging coercion by the Electoral Commission that he be assisted to vote. So there is no basis for the allegation that the number of assisted voters factors into this entire inquiry in any respect at all. It does not. And it has not been shown to the court why it should factor into that inquiry at all. Now, the applicant has put the proposition before you that the Electoral Commission is busy changing results every 2 minutes, and therefore we should not rely on anything that they say. But here's the issue, my lords and my ladies. The Electoral Commission is a respondent in this matter. Serious allegations have been made against it. Was it to sit back and say, well, let the court decide without hearing my side of the story? The only way the Electoral Commission was to effectively respond to this matter was to go into its data and say, let's investigate these claims that they make against us and see, test our own data and see if it stands up. And Annexure Z, which I referred the court to, says the data stands up. There is only a variance of 0.1% when all is said and done. And that does not change the outcome of the election. That does not change the validity of the declaration that was made by the 24th respondent in terms of section 110, subsection 3F of the Electoral Act. That declaration remains correct, it remains valid. The Electoral Commission has not been busy changing results, it has simply been responding to a petition, which almost contradictorily, the applicant accuses the Commission of saying, well, here they didn't respond, therefore they must be taken to have admitted. But where we do respond, or where they acknowledge that we have responded, they say, well, they shouldn't have responded because they are busy changing results now. The applicant cannot blow hot and cold in that way. If he wants the Commission to respond, he must want it to respond to everything he alleges. And most of the things he alleges against the Commission, and the Commission has responded, and it has responded fully. And it has given the statistics from the relevant source data, which is the only source upon which a proper analysis of the 2018 presidential election can be done. It cannot be done on samples, it cannot be done on V11s that are not provided to the court but are indicated in the founding affidavit to exist on a disk that the applicant has kept to himself, which the respondents have had no opportunity to vet or verify or even consider in any material way. The analysis by the Electoral Commission is the only analysis that can be called credible. It is the only analysis that is based on the real data. It is the only analysis that must be taken by this court. And that analysis says the return does not change. The return remains the same. The declaration was correct. The relief sought to overturn that declaration and therefore declare the first respondent the winner of the election cannot be granted. It is not supported by the evidence. The evidence presented by the Commission debunks all of his claims. Now, the other issues that are related to in the affidavit by the applicant are not necessarily issues of statistics or mathematics. They are more general issues which we have dealt with in the opposing affidavit and in the heads of argument. We may just relate to one or two for purposes of illustrating how the positions taken by the applicant are not supported by anything in his papers at all. For instance, there is the much talked about question of the scarf. Now that is something that we believe was just thrown in for mischief. Everyone knows that the period in which they claim the scarf was born was long before nomination court had set, long before the declaration, the proclamation of an election, and therefore long before anything like candidates existed in 2018 for this year's election. So to then take conduct done prior to the existence of candidates in the 2018 election and say it shows you are aligned to that candidate because when that candidate eventually did his election run, he used that clothing for that election run is, with respect, mischievous. It is to put the cart before the horse. There is no way you can say something that happened 5 months ago was motivated by something that then happened 5 months subsequent. The logic doesn't hold up. And we say so in the affidavit. There is no basis to claim that there was bias on the part of the 24th respondent on that score. It is just something that is there in the papers, perhaps to make them larger, but not really to put any substance to them, with all due respect. The question of the postal vote that has been put across, firstly, the applicant misstates the figures. He says there were 7,500 police officers that voted through the post. That's not correct. and we put across the proper postal voting schedule, which shows that 4,446, I believe, police officers are the ones that were approved for voting through the post. And not all of them were at the infamous Ross camp that he continually refers to. This was across the country. So the attribution of those votes in his affidavit to say 7,500 votes should therefore be nullified, again, has no logical connection to what was happening. It is just thrown in there again to say, this is another number, knock it off. He doesn't even say, how does that link to his own election? Were those police officers going to vote for him? Were they not going to vote for him? It's all very vague. It's all very general. It is supported by no evidence. There's no police officer that has come before you and said, my lord, 5 minutes to conclude.
Yes, the only, what time would we have? 5.
Just 5 to wrap up.
Sorry?
5 to wrap up.
5 minutes?
Yes.
All right.
As I was indicating, my lords and my ladies, no police officer has come before the court with an affidavit saying I was disenfranchised by the Electoral Commission through the postal vote. And a decision has already been made by the courts in that respect. Similar perspectives apply for the presidential ballot, the design. That's a matter that is res judicata. Well, maybe not between the parties before you now, but the way that the order operates is such that it is effectively in the form of a declarator, because if the court decides that the ballot is legal, anyone else who comes to challenge will still have to face the same hurdle, and it's unlikely that the court will overturn itself on that point. Now, what is the sum of what we have said? The sum of what we have said is this. There's no application before you. The rules have not been complied with. The figures do not justify what the applicant says they do. He mischaracterizes Annexure Z, the statistical report. He attributes votes for teachers that are not established or by any evidence at all. He uses the wrong voter turnout to claim that 700,000 votes are unaccounted for. He uses and mischaracterizes V11 forms before the court to say they were forged, they were missed, they were blank, and so on and so forth. Now, the only other issue that probably I should deal with is that of the missing polling stations before I take my seat. They say there were polling stations that were created, there were polling stations that went missing. In the entire address by the applicant, not a single name of a polling station has been given to say polling station so-and-so disappeared, or polling station so-and-so was created. What they do in the affidavit, my lords and my ladies, is to say that there is a polling station called 1 HRDC and 4 HRDC which were created on the day of polling. They specifically characterize them as polling stations. In their submissions, they tried to say their words because of the response they were given. But what effectively those 1 HRDC and 4 HRDC are words. The Ward 1, Hurungwe Rural District Council, Ward 4, Hurungwe Rural District Council, which were collations of the polling stations in those wards, which the applicant has, by some means, tried to present to the court and said these were 2 polling stations that didn't exist. That's just not correct. He's taking the court on a tangent, giving it incorrect information and trying to present it in a particular light. It arises from his Annexure M, which we deal with in extent in the papers that have been filed. Now, the net effect of what I have submitted before the court is this. There's no basis for the relief at all. The standard of proof has not been met. The evidence is not before you. Some of it was not even filed, even though it is stated to be relied upon for everything that the applicant wants. The application before you, if the court finds that there is an application, is one that is so deficient of evidence, so deficient of particularity, that it cannot really give rise to anything like the order that is sought by the applicant. The only alternative that we pray should arise from this matter is that it be dismissed. And we pray accordingly. If I could just confirm. My lords and my ladies, I simply emphasize that the applicants did not seek to open the primary data to support their application. They chose to simply come to court. What they say is the poison chalice in the ballot boxes is what we've endeavored to show, that these V11s that they say consist the poison chalice are actually things that they've put before the court in a skewed manner to try and give the impression that there was something untoward happening. That is not correct. They should have opened the ballot boxes. They should have dealt with that properly. And then perhaps the court would have been in a better position to consider their case. That is not what is there. Those would be my submissions, my lord and my lady.
Yes, thank you. There's been this repeated assertion that ZEC abandoned its own figures, the figures that it announced at the end of the election, and those which it produced in the disc. I think that has been Mr. Mpofu's position, that there has been this shift by ZEC, which suggests that there's an admitted error. What do you say to that?
My Lord Chief Justice, we deal with that in the opposing affidavit. We indicate that upon receipt of the petition, the 23rd respondent subjected its data to analysis. There were discovered in that data few minor clerical data capture errors. Those are what are indicated in paragraph 1.5 of Annexure Z as representing a variance of 0.1%, and those do not have an effect on the election result. Now, as I have submitted just a moment ago, there is no basis to say ZEC was busy changing results, because ZEC was only responding to a petition. It was reacting to a petition. And in that reaction, ZEC had to meet the allegations head on. And to do so, ZEC had to go back into its data and see what exactly is being claimed and is it true. Now, in that process, that's where these minor and immaterial data capture errors were discovered. They are enumerated in Annexure Z, and their effect is indicated as being non-significant to the final declaration. Now, what is before you, my Lord Chief Justice and learned lords and ladies, is a request to overturn an election return. That request must meet certain thresholds, and it is our submission that that threshold has not been met by the applicant. The applicant can go to town and say, well, you are changing results, you are doing this and you are doing that, but eventually the evidentiary burden of proof that must be achieved is to say, okay, when you take into account whatever minor clerical errors were discovered, does it change anything? Does it change the declaration? Does it change the result of the election? It does not. The result of the election remains as was declared. The first respondent, on the results that are there, the results that are true, won the election. The applicant, if he alleges that there's something in the ballot boxes, well, he ought to have opened them and said, well, here's the smoking gun. Look at it and see what they say. But he did not do it. And so he must rely on the data from ZEC.
What about the issue, the allegation pertaining to Marsh Central, the alleged apparently influx of voters beyond 6 p.m.?
My lady, that particular point can be answered in conjunction with the general point that is made by the applicant, that there were anomalous voter behavior or voter turnouts in certain areas. Now, the first thing that must be understood is that the reasons why voters behave in the way they do is not something that can be subjected to pure statistical analysis. Voters behave the way they do, no one knows why. Maybe behavioral scientists may be able to answer the question if they study it. The Zimbabwe Electoral Commission cannot be taken to task to say, why is the voter turnout in Marsh Central at this particular level and not at that particular level? Because the Zimbabwe Electoral Commission does not go out and seek voters to come and vote. Simply facilitates the casting of the ballots. If the voters decided to come at a particular time, that has nothing to do with the Electoral Commission. But more importantly, it is an issue that again goes back to the ballot boxes. If you say that in a province that has a voter population in excess of 500,000, and you accept that there was a voter turnout in their own papers of at least 72%, then you must also accept that there will be an influx of voters that comes up to about 380-something thousand on their own calculation. On the correct computation, upon 85.1% voter turnout, it comes up to something in excess of 400,000. The logic of it is clear. It is supported by the data that was received all over the country, the voter turnout all over the country. There is no real basis that is placed before the court to say, look, there could never have been this many people in Marsh Central who voted. And again, it is not exactly clear how they went about sampling these polling stations to find out at what time this number of voters had come in and so on. Again, it goes to the particularity or lack thereof in the petition. If the applicant wanted to prove that less than, as he states, 200,000 voters voted in Marsh Central, his best weapon was the ballot box. He didn't go for it. He let it go. He must stand or fall by what he put before the court. But in any event, those figures for the turnout and the numbers for Marsh Central are correct.
Mr. Kanengoni, there's the averment, which I don't think you've addressed, that several polling stations showed identical results.
Thank you, my lord. We do address that issue in our opposing papers, where we actually annex, I think it's 2 of those polling stations where such results, such returns were actually found. It's just that I will have to look in the bundles to see where that is exactly. If I could just check. I believe we attached the results for, if the court would just bear with me for a moment, that's Wange East constituency at Mashala Top Building, British Preschool, 726 of volume 2.
Seven.
726 of volume 2.
26. 726.
Yes. I hope the pagination is similar.
The Annex 1?
I beg your pardon, my lady.
Does it say Annex 1?
Yes, Annex 1, exactly. That's the one. As we take from the applicant's own list of polling stations that he says have identical results, that could not have happened. And the simple point we make is that there's no need to be theoretical about it. We have the returns. This is something that happened. We show you the returns. And we've put the returns for 2 of those polling stations here to illustrate the point. Now, the applicant tries to use probability and say it's improbable that that would happen. But that can only be used before the event occurs, if you're trying to predict a future event. But if the event has already occurred, you simply go to the data that you collected when the event occurred and say, okay, did it actually happen? You say it happened, did it actually happen? Show me the V11 that proves that it happened. And these 2 polling stations are in different areas, and they are signed by different polling agents. So there's no way one could say, well, this is some scheme to rig the election. This is the fact. We put it before the court. The applicant simply says it's improbable, but gives no evidence. We give evidence, and our position must then carry the day.
You say it happened?
Yes.
These 2 polling stations you're talking about?
Well, it's not particularly identical in the full sense, but the
Sorry?
votes, it's not identical in the full sense,
Yes.
but the votes for the 2 polling, this is a comparison that we do not take on our own. We take it from the applicant's papers. It is the applicant that has put this comparison before the court to say this is not possible in his list of polling stations that he says had identical results. So we simply took a sample and said, let's go to the V11s and see and test the applicant's theory, which says it's not possible, and these are the V11s.
But in his presentation, Pofu says it's actually 16 polling stations where the identical results. You heard it?
Yes, we did. Even in the affidavit, they put a bit more of the polling stations there. But we chose this to illustrate to the court. But for the rest, it did happen. And the V11s are there to prove the point. It did actually occur.
So the point you're making is that in respect of these 2, MDC Alliance got 86, at Mapengula, and 86 at Mashala. And Emerson Mnangagwa got 52 at Mapengula and 52 at Mashala. Although the total number of votes is different.
Apologies. We don't take this example from our own perspective. We go into the applicant's own list and say, from what you have given us, let's, at random, pick 2 polling stations that you say could never have been the same, and then we produce the V11s in that respect, to show that it is not something that is subject to probability anymore. We must actually just give you the V11s and say, look, it did happen. Now, if the applicant was saying, this is nefarious, something happened here, he should have then produced what he considers is the correct V11 for those polling stations. Because obviously, his allegation that this could not have happened must be attached to an averment that I have the correct V11. That one which you have produced is wrong. It's forged. It is part of your rigging. He hasn't done that. And it is his onus to do so.
Were these V11 forms signed by the election agents?
Yes, my lord, they were. They were signed by election agents for the MDC Alliance, for ZANU-PF, for PRC, I believe. And the agents who signed are different. It's not like they were at the same place and signing these things and saying, let's forge these documents. Very different agents who belong to the applicant. And those agents haven't been brought before the court to say, I was at this polling station and that is not the return that was found at that polling station. They haven't brought them before the court.
Mr. Kanengoni, an allegation has been made or an argument has been presented before us that more than 40,000 or 40,000 more voters voted in the presidential election than in the parliamentary election. Do you want to comment on that?
Thank you, my lady. That's one of the things I had left out on the numerical aspects of this matter. My lady, let me start by reiterating that in terms of our law, a voter is not enjoined to vote in all 3 elections. Section 56, subsection 3A of the Electoral Act.
Sorry, what section?
Section 56, subsection 3, small letter A of the Electoral Act allows a voter to choose whichever election he or she wishes to vote in. That's the first thing. The second thing is that there are uncontested races that happen in elections. In this particular election, there were about 47 local authority races that were uncontested. There were also 2 House of Assembly.
Could you repeat that?
There were 47 local authority elections that were uncontested, and therefore no poll was held in those 47. So no ballot was created for those 47. Now, the applicant's party did not field candidates.
For parliamentary seats?
It was for local authorities.
Yes, for parliamentary seats?
For parliamentary, I believe all were contested, but not all by the MDC Alliance. 2 were not contested by the MDC Alliance. I believe one is in Caesar North. The other one doesn't come to mind quickly, but it is in our opposing affidavit. So the third point that we make is that in certain instances, you find that voter behavior is such that if they do not have a House of Assembly candidate who is congruent to their preferred presidential candidate, they can opt out of the House of Assembly election. In Caesar and the other constituency, I do not remember it offhand, my lady. But eventually, this is where the inquiry must come. The inquiry must come to the V11 again. The V11 has on it a ballot paper audit at the beginning. I have referred to it before, the one that records the books, the number of ballot books that were received. That then is juxtaposed with the number of ballots that were actually used, which are counted and verified before the unsealing of the ballot box and counting of the ballots in the box. So if everyone who is there, the agents, the observers, and so on, find that the ballot paper account that they have done differs from what they find in the ballot box, then that is the first red flag that they raise to say, well, you received 100 ballot papers, you used 50, but now in the ballot box there are 60 ballots. Where did the 10 come from? That's the evidence that the applicant should have brought and said, well, this is what accounts for the 40,000. This is the inflated or stuffing of ballots that happened. But he doesn't do that. He doesn't present us with any of his election agents who say, when we did the ballot paper audit before counting, we discovered that what we audited was not the same as what we found in the ballot box. In the ballot box, we found more ballot papers than were used on the ballot paper account. There are no observers who make note of any such anomaly. It is an anomaly that the applicant simply throws and says, well, there's a difference, therefore there must be something wrong, there must be something irregular. But he does not give you evidence or any kind of particularity as to why he says so. And in our respectful view, this would have been proven simply by looking at the V11s that are in the boxes and saying, well, this ballot paper account does not match the number of ballots that you counted. Or bringing agents who will say, well, this is what happened. There are none that are brought.
Do I understand you to say that evidence to explain this phenomenon is available and it is there in the ballot boxes? Is that the position you're...
Effectively, my lady, that's where it is. And you will find that in those ballot boxes, the applicant will find no joy at all in his allegations.
The allegation that there, in some places there were more votes than the registered number of voters?
Yes, my lord, that is the issue that I related to when I took the court through Annexure V, which tabulates the various polling stations that the applicant alleges there was overvoting. And we put the V11s to the court to show that there was no overvoting, and a verification by ZEC on a schedule for each province.
Yes, thank you, Mr. Kanengoni, for having taken us through the position for the last three respondents. There are no more respondents in the primary cases. We'll now go back to the applicant and give Mr. Pofu the opportunity to reply.
Thank you, my lord. Let me begin with the position of the first respondent. Lord, how much in terms of time? How much in terms of time?
Sorry, the rule 41. You start with rule 41 for replies to start with. Then you can ask for time if you want.
That would be 5 minutes.
Yes.
Maybe the only. Well, I'm going to ask for more time.
You will ask for more time.
Indeed, my lord. I will.
If you want time. If you want more time.
I could just ask for it in advance.
Sorry?
I could just ask for it in advance.
You want to ask for it in advance?
Indeed, my lord. Maybe if I could try some 20 minutes?
15 minutes.
20 minutes, given that there are two respondents.
What time do you want?
20 minutes.
20?
20 minutes.
All right, we'll give you 20.
Thank you.
So we'll give you 20 minutes for you to reply.
Thank you.
All right.
I begin with the position of the first respondent. First respondent says he's won an election. You must know why he says he's won an election. In his is away from the numbers. He's so scared of dealing with applicant's case, he prefers to deal with the case that is not before the court. At page 29 of volume 1, applicant sets out the remit of his challenge. He makes it clear that he wishes to deal with this matter from both a process perspective and also from a mathematical perspective. It is true that he sets out a background. He calls that the subsidiary challenge. But the real issue and the issue on which we have argued, this process issues, the numbers, but the first respondent who claims to have won the election just does not want to deal with that. I take the court, if I may, to the judgment in Changirai versus Mugabe, where the court says they were conscious of the fact that elections can be stolen, like this one. They were acutely aware of the possibility that a candidate who cries foul after losing an election may, after all, have the truth on his or her side. If a candidate cries foul, on a certain and given basis, it is incumbent upon a respondent to try and meet that candidate on that basis. Malene Trends submits that the allegations are of a criminal nature and the test is one beyond a reasonable doubt. There is no warrant for that kind of position in our law. Let me just make this point. If it appears to the court that there's been a genuine error, and the genuine error is given a candidate votes that is not entitled to, the court will set aside that election on that simple basis. So when there is a mathematical challenge, it becomes important that parties deal with that issue. Now, when ZEC starts revising its own figures, the presumption of regularity goes away. We must now deal with the figures that it places before the court and let ZEC establish the validity of those. I'll shortly come to that. I just wish to explain that the issue of the separate bundle on which much is said is completely irrelevant. We have our objections on how that bundle was treated, but at the end of the day, it doesn't matter. The applicant's fundamental challenge is process and mathematics based. I go to the question of the residue. Section 70, subsection 3 of the Electoral Act clearly deals with a parliamentary election. It is so clear. But then there is a judgment on the issue, which is also an answer to the position taken by the respondents. It is Timber versus Chief Elections Officer 14 ECH 001, where the court says because the elections were harmonized, you cannot, under those circumstances, ask for the opening of the residue. I would commend the court to that judgment. So Section 70, subsection 3 does not at any rate come to it. The first respondent then says the applicant gets these figures from nowhere. No, he doesn't. The applicant has taken ZEC's figures and shown the inaccuracies of those figures. The applicant has taken the voters' roll given by ZEC and shown the inaccuracies of the figures announced, particularly as they relate to that voters' roll. And that with respect is very clear. I take the court as well, if I may, to page 151. That is the first bundle. No, I have a pagination issue on that. I'll come back shortly to that. Let me deal with this figure of the 72 and 85% issue. That comes from ZEC's own processes. For now, and just to deal with this without dwelling much on it. If ZEC's own position as it appears at page 159 of volume 1 is taken into account, we exclude 370,000 votes. Further, if ZEC's own position as it appears in Annexure U is taken into account, where it says by 6 p.m. Mashingo it recorded a 60% voter turnout, we are also excluding some 200,000 votes again. So based on those concessions by ZEC, we are already above 500,000. My learned friends then argue that there was a similar trend in Harare where there was an upsurge of voting in the last hours, but there is no such evidence before the court. We have demanded that evidence. There is simply no evidence to sustain that contention. The first respondent then says he won the election and his tally takes him to 50.67%. Where does he get that? In terms of section 110, two things happen after votes have been, or after the figures have been collated. Number one, ZEC must be satisfied that there is a winning candidate, and that winning candidate must have 50 plus 1% of the vote. So it is a numbers issue.
So 1% or just 1?
50 plus 1. Thank you, my lady. 50 plus 1. It is a numbers issue, a declaration.
You mean 50%?
50% plus 1 vote.
Plus 1 vote.
So a declaration is based on a figure. It is based on an actual figure. If a declaration is made on a figure and that figure turns out to be wrong, that declaration cannot be correct. I then move to the position of Magunje. That position is set out at pages 86 to 88. This is what Magunje says, and which none of the respondents is responded to. He says those two words are accepted as correct, that the document relates to words, the document at page 168.
So what page are we looking at?
Page 168. This is 165. Those two words which produce that total of plus 5,000 for the first respondent.
Volume 1.
That is correct, my lord. That's volume 1.
I see it. Volume 1. It says 168.
Now I invite the court to consider the deposition on that issue. It is at page 88. This is what Tawanda Ralph Magunje says. Paragraph 1.3. Suddenly, additional figures were brought in from what was claimed to have been some polling stations in the area. I was in the area. I was a contestant and knew nothing about those polling stations. ZEC had published the polling stations for the area, and the concerned stations were not part of those published. In addition, I had moved around in the area and had not observed any such stations. So this is what he says. Those figures were said to have been tallied from some polling stations, but those polling stations were not in existence. ZEC published the polling stations that were going to be in existence. And no polling station answering to these two collations was in existence.
Sorry, Mr. Mpofu, to break into your stride, but I believe that one of your learned colleagues indicated that that affidavit should be disregarded because it was not served upon them. I have been trying to go through my notes to find out who said that, but I recall one of them made that submission before us. For the first respondent, I think it was.
I do not know where they take that from, my lady. I take you, if I may, to the consolidated index. The consolidated index, item 11, shows that that affidavit was included by the parties. They accept that it was filed. In fact, if the court has regard to the parties inspected the record, and after the parties had inspected the record, they agreed on what was to be contained in the record. And this affidavit is one of the issues. In fact, ZEC, which must deal with this affidavit.
Sorry, on what page is the affidavit once again?
Pages 888, 86 to 88.
It's missing in our
86 to 88, my lord.
8. Oh, it says missing 86 to 88, missing. So we don't have that affidavit.
Lady, we must now place it before the court. The parties have agreed. This index was prepared by the parties. They agreed that these are the documents which were part of the court record. These are the documents which they had.
So are you,
23rd
sorry, Mr.
respondent.
Mpofu, are you saying, because I also seem to remember what my sister here remembered also about an affidavit not having been part of the papers served on the other side. You are saying it's not, well, we don't have it. You are saying it's not the one which should be on page 86 to 88.
Lady, this one was definitely served, and when the parties prepared the index, they agreed that it was part of the index. In fact, ZEC refers to the affidavit in its own opposition. But what ZEC says is that you are talking of polling stations instead of talking of wards. But what it does not do is to deny the allegation of fact made to the effect that these results came from non-existent polling stations. That it does not deny.
Yes, you may proceed.
So if it is not part of the record, Lord, we would have to, by separate note, just ensure that...
Yes, just proceed with your argument. You are in reply.
Thank you, Lord. I then move to the question of the teachers. The 40,000, the 60,000 number is given by the unions which made an application and obtained an order. And the account for that number, it is at page 117. At page 117, they make it clear that at least 5 teachers were assigned per polling station. And one does the quick math, it takes us to that figure. But the applicant's issue is not that all the teachers would have voted for him. The applicant's issue is that in an election where the margin is 31,000, you cannot disenfranchise 40,000 people and still retain a valid election.
Were they all, can anybody say they were all registered voters?
Lady, that is now up to ZEC to establish, because it is ZEC which has disenfranchised them. And it would not have disenfranchised them unless they had the right. I then just deal briefly with the issue of the experts. The question of the experts, Dr. Otumba, we rely clearly on his analysis, and that analysis is accepted by the ZEC expert. Dr. Otumba is a doctor of statistics. Page 10 of the Raila Odinga judgment, which we have placed before the court, shows that he is the one who gave evidence in the Raila Odinga matter on which the court relied on. So for the first respondent to say he only knows things about fish, and then they've placed an affidavit of an expert who is a lecturer at the University of Zimbabwe and only has 1 degree, is with respect completely unacceptable. It's so rich coming from the first respondent. Now, I move to the issue of the filing of the application. The Black's Law Dictionary says to file is to lodge. And says to lodge is to file. And the word file is rendered thus: to deliver a legal document to the court or clerk or record of or custodian. But let us go to section 93 of the Constitution of Zimbabwe. Section 93 says, subject to this section, an aggrieved candidate might challenge the validity of an election of a president or vice president by lodging a petition or application with the Constitutional Court. And that agrees with the definition of lodging, of filing, as set out in Black's Law Dictionary. The first respondent then suggests that once the sheriff refused to serve we should have approached the registrar who would have placed the issue before a judge of this court. That with respect is completely without merit. By the rules, the office of the registrar closes at 4. So at a time when the sheriff refused, there was no registrar to approach. So that argument, which is taken by the first respondent, is without any validity at all. I then go to section 169. It is true that section 169 of the Electoral Act must, in terms of paragraph 10 of the 6th schedule, be read together with section 93. Now, the reading together only changes one thing: the time frame for lodging. But what remains upon a consideration of section 169 is this. It is that there is a difference between filing and service. And section 169 is very clear on that. So I would submit that that provision is important, it is relevant to the determination of the matter before the court. I then move to ZEC's position. Now I want to make these points at the outset. The legal onus is definitely on the applicant. The evidentiary burden, however, shifts. It is a roving baseline. It shifts depending on what has been placed before the court. It shifts depending on what has been accepted. It shifts when one considers who it is that is going to lose if they fail to place evidence before the court. Now, what do we have under the circumstances? Before the application was filed, ZEC changed its results. And that is at page 138. There is, the annex at page 138 shows the change of the results by ZEC from those announced to the CD results. After the application had been filed, ZEC changed its results again. So it is not correct that ZEC has changed results in response to the application. It changed those first before any application had been brought. Now, once ZEC has changed the results 3 times over, this with respect is the legal implication. To the extent that ZEC had claimed that the results it announced tallied with primary data, once it changed them in terms of its CD, it had to establish that those results comported with what is contained in primary data. It did not do so. Secondly, that change ought to have been verified, because the law requires a final result which is binding to pass through a verification process. That was not done. ZEC has now changed in response to the application. Now ZEC occupies a very important position. It is the one that runs the election. It is the one that has all the material from the election. We have to gather the material. ZEC has it. So when it changes its result again, it bears the evidentiary burden to establish that its new change, which it wants the court to validate, is based upon primary data, and ZEC has not been able to do so. That election, in which results change 3 times in 2 weeks, cannot be a credible election. It cannot be a verified election in terms of the Constitution. It must be wholly vacated. Now, I wish to deal with the figures because ZEC tries to deal with the figures. But let me set out first the figures which it has not dealt with. Some of the figures it ended up dealing with as a result of questions that had been put. The first figure that it has not dealt with, Lord, my Amara, I just asked for some 5 minutes. 5 minutes. 5 minutes, my Lord. Let Fred suggest that maybe I take 10. 5 minutes. Thank you, my lord. The 8,944, which is contained in paragraph 1.5 of its expert's affidavit, has not been disputed. The 7,730 has also not been dealt with away by ZEC. Now, let me just explain that the difference between 8,944 and the 7,730 is stark. When ZEC deals with the 8,944, it is accounting for the difference between the results as announced and those on the CD. That is the one aspect. The 7,730 relates to the inflation and the deflation in Mbire and Rushinga. It is once again a different figure. So the court will notice that these two do not tally. If the 8,944, the 4,400 and the 4,100, 4,400 and whatever, had taken the double collation in Mbire and Rushinga into account, the numbers would have tallied. But they do not tally because they relate to different phenomena. So we are already at 16,000. The 40,000 parliamentary is unanswerable. Section 53 of the Electoral Act says, if polling in two or more elections is being conducted simultaneously at the polling station, and an applicant declines to accept a ballot paper for any one or more of those elections, the presiding officer shall not hand the applicant a ballot paper for that election and shall record in such manner as may be prescribed or directed by the commission that the applicant did not at his or her request receive the ballot paper. So there is a prescribed manner, which I've already dealt with. So what ZEC must do is to show that in respect of these 40,000, they declined. But the court will notice that in its affidavit, it relies on speculation. In the affidavit of its expert, it relies once again on speculation. It does not say these people refused. That is not its case. But the law says if there has been a refusal, record. And if they've recorded, they must place before the court. Those 40,000 votes cannot be accounted for. The 9,592 from the ghost polling stations cannot once again be accounted for. ZEC has not denied that those came from non-existent polling stations. The inflation for first respondent at 10,343. The deflation in respect of the applicant at 19,722 has also not been accounted for. Then comes the Mash Central and the Mashingo issue. ZEC is not talking to children who are in the playground. It is talking to a court. Is it humanly possible that in Mashonaland Central, in 1 hour, 30 minutes, 370,000 people voted? That is what ZEC must deal with. And it chooses not to deal with that. Then there's the postal ballot debacle. ZEC accepts that that manner of voting is not lawful. And then it gives us a figure of some 4,400 and says, but others were from different stations. But how many voted at Ross Camp? And did this not happen in all other respects? It is for ZEC to account for that once it is accepted that this illegality occurred. And from the papers, its own constituency elections officer did not know that this was happening. Then there is the issue of the identical results. 16 polling stations. What is ZEC's answer when something which is that incredible is placed before the court? Because that is what an applicant can only do at this stage. ZEC decides to place before the court 2 V11s. Why not place the V11s for the 16 polling stations and establish before the court that something which all of us who are saying no cannot happen did in fact happen? ZEC has failed to do so. And that accounts for 9,592. We are way above the threshold.
Out of interest, how many polling stations would you say were in Mash Central?
You don't know. I don't have those offhand. I don't have those offhand. Then finally, let me deal with the scarf issue. But maybe before I do that, at the end of the day, this is the question that remains before the court. If first respondent won the elections, bearing in mind that Section 110 requires a figure, what is the figure that he garnered? If that cannot be answered, if that question cannot be answered, and it cannot be answered when ZEC acts in the way that it does, then the election must be invalidated. Let me just deal with this issue of the scarf. It shows why is the court ought, in my respectful submission, to adopt a very strong position when it comes to ZEC. The chairperson says she wore the scarf before the first respondent was nominated. But the first respondent was always the ZANU-PF candidate.